said by scholars that it is an entitlement not to be contacted by employer during out-of-work hours as per the employer's policy. There must be a policy that is guiding every employment and creating a workable environment in every organization. Mr. Speaker, this encourages the right to privacy. Some people have made telephone calls being the boss, even in midnight, calling somebody's wife or husband, causing disunity in families. We need some kind of a working relations that dignifies a worker. Simply because he's working for you doesn't negate. The second thing I wish to refer, Mr. Speaker, is that in corporate governance, there is a cliche of professional distance. This is where we exercise it. Yes, no doubt, there are areas where relationship between the employer and employees are strong, well-connected, caring relationship with the people and all that work together. That one is encouraging transformational type of leadership where staff owns the organization. Then you need to have a high level of motivation and several others. Mr. Speaker, in principle, I wish to support this bill, but I want to agree with the speaker that has just spoken that there are so many areas that needs to look at the gaps. With that, Mr. Speaker, I support.
The Honorable Gitonga Murungara, do you want to speak on this? Proceed.
Yes. Thank you very much, Mr. Speaker. Mr. Speaker, I have gone through the bill as presented from the House of the Senate. I've also gone through the committee report as prepared by the Labour Committee. And having looked at this bill, the cardinal there is no way you can confer rights upon persons without corresponding obligations on them too. I am not very sure where this bill has been lifted from, but it seems to be actually in contravention of employment laws in the country, and especially bearing in mind that employment law is civil law. It is not criminal law, it is civil law. It is based on contract between two persons, an employer and an employee. There are always arguments whether this contract is at arm's length, but provided that it is supported by consideration, it is a valid contract, and the courts have held so. When you confer a right on the employee to disconnect from their employer, the next question is whether the employer has a right to disconnect from the employee. It cuts both ways, because whatever makes an employer to connect with an employee outside the working hours may be the same reason why the employee must connect with the employer outside the working hours. Therefore, one reason I oppose this bill is due to the fact that it does also not give that right to the employer to disconnect. Let's move on to the element of disconnection, which is actually criminalized by this particular act. That if anyone contravenes this section, it's liable on conviction to a fine not exceeding 500,000 shillings or imprisonment for a term of 1 year or both. First and foremost, the fine and the prison term are disproportionate. you cannot be fined 500,000, and if you fail to pay, you're in prison for 1 year. It has to be commensurate. So the number of years must be slightly more than what is provided here. Number two, this is a contract between two parties, such that one party breaches the contract. Why would the other party be taken to court, convicted, fined, or sent to prison? The remedy for civil cases, for civil breach of civil rights, is actually damages. So the employee should be entitled to an action in damages if the employer breaches this particular provision. I have seen there is an exemption on essential services which are listed under the Labor Relations Act. But essential services may not necessarily be what we know in common life. There may be a reason why an employer would want to connect with the employee outside working hours, purely to ensure that an element of the contract being executed is actually performed. Correspondingly, there may be a reason why the employee would want to connect with the employer during outside hours. For example, during time of illness, where we have to get maybe a cover to hospital, an ambulance to hospital, or whatever other aid that may be necessary. Number three, we know very well in contracts of employment, we have working hours. These are always set out in a contract of employment. If you work outside those hours of employment, you are entitled to a payment. That payment is known as overtime because you're working above the hours prescribed for you to work. Now, what is the problem with an employer connecting with an employee to work overtime, for which there will be commensurate remuneration? I don't see any, and this is why I oppose this particular bill. In essence, this bill goes towards breaching contracts of employment both ways. It does not help modern day market in employment as required. We know employment market has evolved over a period of time, beginning with the communal African societies where there was actually no employment, all work was communal, and nobody expected any remuneration. From there, of course, we went to the ugly scene of slavery, where some human beings felt that they were entitled to labor without paying for it. Exploitation. That was allowed, and we moved to another era of master-servant relationship. This is where the employees were tormented by their employers on the basis that they were servants while their employers were masters. Today, we've moved to what we believe is almost an actual situation of labor relations, contracts between parties at arm's length. And this is where we find this law coming in to actually breach that particular relationship. And finally, which court is going to deal with breach of this particular section?
What's your point of order? Because
Thank you very much, Honorable Speaker. I'm raising person to start on number 35.
wow. Proceed.
Thank you, Mr. Speaker. Mr. Speaker, I think because of the issue of the quorum, we can ask the mover to reply. Thank you, Mr. Speaker.
You have not pronounced yourself clearly on the standing order. that you are actually raising. So
Thank you,
you
Mr.
are
Speaker.
combining two things there.
Thank you, Mr.
Moreover,
Speaker.
to reply, you are also talking about quorum. What are you talking about, Honorable Member?
Thank you very much, Honorable Speaker. I have just consulted with my senior here, and he has advised me to come back to that point of order later. Thank you, Mr. Speaker.
Very well, Honorable Member, you may proceed.
Thank you very much, Mr. Speaker. Mr. Speaker, Honorable Kururia is a young legislator. He's learning how to handle the ropes, and soon he will know the distinction between the two and when they can actually be raised. But I think this is a bill that has a lot of interest, and we may debate on it slightly more before the mover is called upon to reply. Then what I was saying is the labor relations under the Labor Relations Act are governed or are enforced by our employment courts. Our employment courts are not criminal courts, they are civil courts. So if anybody breaches this particular section, which court is going to be charged with arbitrating between the parties on their rights, and especially when it comes to criminal justice? Would an aggrieved party go to the CID, the police, the DPP to complain, after which the DPP would prefer a criminal case against the offending party? That is what we ask. Or will the aggrieved party go to the Labor Relations Court, file a civil complaint for the person to be held liable and award damages? That is another question. As I conclude, Mr. Speaker, this is a bill which, in my estimation, has not been properly thought out. It is not actually in consonance with our employment laws, and it needs to actually be rejected. So I do oppose this bill entirely.
The Honorable Elachi.
Thank you, Mr. Speaker. I also rise to reject this bill. And Mr. Speaker, when I listen to the speakers that have been there.
Yes, what's your point of order?
Thank you very much, Mr. Speaker. I rise pursuant to Standing Order 83, as read together with Standing Order number 95. Mr. Speaker, as you have just heard, everybody who stands rejects. Would I be in order, Mr. Speaker, to request you to call upon the mover to reply, so we don't waste a lot of time with rejection, because it appears has been totally rejected, including even the Honorable Elachi. She just opened her mouth and she said, I reject, before she says so. So, Mr. Speaker, I think we would be wasting our precious time without anticipating the next order. Mr. Speaker, would I be in order to request you to call upon the mover to reply? I thank you.
We have heard you, yes, but let's allow the Honorable Elachi to finish, and then I will put the question to just weigh what the House mood is like. Proceed, Honorable Elachi.
Thank you, Mr. Speaker. Mr. Speaker, it will be good to give with reasons that, first of all, Mr. Speaker, when you go through the content of the bill and look at how we manage the laws of employment in this country and just across the world, Mr. Speaker, and the person who thought about this seems to have not looked at our Public Service Commission Act. That indeed, even when you are employing, he never even specified what cluster of employees is he talking about. Because if they are civil servants, then you can't treat them according to what he would wish. And therefore, he's either talking to a group that we have not seen working in this country or is about to come, so that you give them such regulations, knowing very well the moment you go to an interview, Mr. Speaker, and you are given now a letter of acceptance, then there are rules and regulations of that institution that you abide in as their code of conduct of work. And Mr. Speaker, I normally say there are 5 behavior models for an employee in any workplace. 1, trust. 2, you must learn how to deal with conflict, commitment, accountability, and results. Now, when he talks about time, that when you go overtime, that now the employer cannot even call you out of working hours, what about if you, as the employee, has been given an assignment, you have been so slow on your assignment, and you have to go, indeed, beyond the hours that you were employed? What happens to this person? Will he take advantage and use the same policy to take his employer to court? So, Mr. Speaker, when we look at such a bill and when we tell the Senate, and I want to tell the Senate, when you're talking of employment, it is the most sensitive thing. And that is why any lawyer who walks in court on a matter of an employee, the first thing the judge does is to give orders to that person. Then you now come and go through your case. So if they find you culpable, yes, you will go home. If not, but always you are given orders to return to work. And therefore that protection is there for any person who is employed in this country, Mr. Speaker. And therefore for them to come and now define, unless we are saying, and I'm not saying us, I look at the Senate and I want to tell them they have to be looking very critically at the work of our people who have been employed in the counties. They need a critical law just to get their pension. How I wish they can bring that in this house. They need a critical law to safeguard them in how you find a governor can just decide today, Mr. Speaker, you are not there, you won't be employed, you have been employed for 10 years, you are thrown out in 1 second. They need now to bring an employment law for county government workers that can protect them properly in the work they are doing and ensure even this overtime. Most of them do not get. So you find county assemblies are even more organized than the executive side. So how I wish that is what they can do for us, so that even those in the executive side can find themselves in a proper way and a proper contract. If I'm given a contract of 3 years, 4 years, 5 years, it does not become a political contract, but it becomes a contract like any other person who is employed in this country. So for them to bring us this, I think it is very unfortunate, but I want to say we are not rejecting this bill, Mr. Speaker, because it is a Senate bill. We are saying you are contravening the laws of employment in the country. They are well stipulated. We have different articles that take care of that. If you want to amend, then you have to go through all those laws and then bring an amendment that is very clear, and we shall look upon it and be able to support. Lastly, Mr. Speaker, we have to also inform the Senate that when you are talking about employment, please cluster so that we understand. Are you talking about those who are on contract? Are you talking on pensionable and permanent? Are you talking about informal? Are you talking about our Adobe services? Who are you giving this law to enjoy? Because even if you ask who are the beneficiaries of this law, the civil servants, Mr. Speaker, our teachers, everyone can never be a beneficiary of this. Because if you are a teacher and you have students who are in boarding school, you already agreed with the code of conduct that I'm in a school that is a boarding school, and you can be on duty at any given time. And therefore, you will receive calls from your principal or even from above beyond to ensure that safety is taken. So as much as we would wish, Mr. Speaker, I want to say it was unfortunate for a bill like this to come here, and also unfortunate in public when they went for public participation, I'm wondering who they went through, because some people would have also questioned, even those stakeholders who employ, they were supposed to also say a few things on this bill so that both parties can be in an agreement of how to do it. With those few remarks, Mr. Speaker, I beg to reject.
The Honorable Bernard Kitur. You know, Standing Order number 95 also depends on the prerogative of the Speaker to make a decision on the same. I've already made a decision, and therefore, Honorable Bernard Kitur, you may proceed, if you want to speak on this.
Well, Chair, Mr. Speaker, sir, I stand to reject this Employment Amendment Bill, Senate Bill number 11 of 2022. And first of all, on the fact that in as far as it's important for employees to be respected by their employers, and that it's also important to have a time frame of work, because when you do have a contract between an employer and employee, it should be stipulated based on time. And as far as it's a progressive bill towards bringing in order on areas of employment, I do find that it doesn't fit the Kenyan model of saying that, for instance, you come in at 8 and by 5, you completely disconnect. You cannot be able to engage with your employer. I do not think we've reached to that point where we operate in a way that when it gets to that stipulated time, everything completely disconnects. So I don't feel that it is a practical bill in itself. And secondly, there are issues that had been raised that it helps to reduce exploitation by the employers, which wasn't very clear as such. I still want to also raise that this amendment only fits employers in the private sector, but not much those in public sector, like those working in government or teachers and such kind of jobs. So, to me, I still feel it is not balanced. Also, the aspect of saying that this only applies for organizations that have more than 10 employees is also discriminative. What happens for those that have less? Therefore, I do not want to belabor much, but on the overview, I stand to reject this bill. It is a good one, it has come in, but I don't think we are in that space that we can be able to have such a very tough bill. Of course, I saw also the punitive measures that happens for those that break the law in as far as this is concerned was very punitive to the employers. So it needs to be a bit more balanced. So for me, I stand to reject. Thank you, Mr. Speaker.
The Honorable Zamzam Chimba.
Asante sana Mheshimiwa Spika. Na mimi niweze kusema kuwa japokuwa nia ya kuleta mswada huu ilikuwa nia nzuri, lakini tukiangalia kwa undani tunaona kuwa itawanyima wengine raha ya kufanya kazi kwa amani, Mheshimiwa Spika. Kwa hiyo Mheshimiwa Spika, mimi napinga marekebisho katika mswada ambao umeletwa leo kutoka katika bunge letu la Senate. Mheshimiwa Spika, wafanyakazi katika taifa hili wameangaliwa vizuri na wamewekewa kanuni na sheria na masharti na mambo yao katika katiba yetu. Ukiangalia katika kitengo cha ajira wameangaliwa vizuri sana, Mheshimiwa Spika. Na hii nikiangalia itakuwa inalemea upande mmoja na wengine watakuwa pengine kama mwajiri atakuwa amelemewa sana, Mheshimiwa Spika. Katika serikali yetu sisi tunataka mfanyakazi akiwa na furaha na mwajiri naye pia awe ana furaha na kuangalia pia kazi yake, Mheshimiwa Spika. Kwa hiyo Mheshimiwa Spika, haya marekebisho yalioletwa, kwa mfano hapa juzi Mombasa nimekuwa sehemu nikiangalia sheria za wafanyakazi wa EPZ, Mheshimiwa Spika, lakini tukafikia maelewano kuwa lazima wale wafanyakazi haki zao za kimsingi ziangaliwe, na vile vile pia haki ya mwajiri naye pia aweze kuangaliwa ili waweze kupata balance, kwa sababu tunataka taifa ambalo linaweza kusonga mbele kwa mwafaka uliowekwa katika katiba, Mheshimiwa Spika. Kwa hiyo katika hili mimi nitamwambia kamati ya Leba katika Senate, hili kama mama kaunti wa Mombasa nimelipinga. Lazima sheria ni msumeno ukata mbele na nyuma, tukuangalia mwajiriwa, tuangalie na anayemwajiri, Mheshimiwa Spika. Lakini hata hivyo pia walete sheria na kanuni nzuri ambazo sisi tuweza kuzipitisha hapa, kuangalia haki za wafanyakazi zinafuatiliwa sana, Mheshimiwa Spika, kwa sababu kuna watu vizuri. Na mimi ujumbe wangu pia kwa wafanyakazi wa EPZ Mombasa, na nyinyi angalieni kazi yenu, tusiweze kufunga makampuni yakienda Kenya yahitaji pia kujengwa na watu kama hao. Mambo yenu yameangaliwa vizuri, na nyinyi muangalie zile target zenu, zile kazi zenu mlikuwa mmepewa kufanya, mufanye kwa uadilifu ili tuweze kuona makampuni yetu yakienda vizuri. Asante sana Mheshimiwa Spika.
The Honorable Beatrice Kimei.
Thank you, Honorable Speaker, for giving me this opportunity to add my voice to the bill that we have, the employment, that is Amendment Bill 2022, the Senate Bill number 11 of 2022.